The judicial branch, described in Article 3 of the Constitution, is the least precisely described branch of the three. Congress is described very carefully, the presidency and the executive branch a little bit less so, and the judicial branch not very much at all. In fact, the power of judicial review is not directly stated in the Constitution, although it's pretty clear that would be the function of the court at some point. Congress's relationship to the court is a little different than its relationship with the president. The relationship with the president is an ongoing relationship because it involves lawmaking and oversight. The relationship to the court is not nearly as ongoing. Congress's power, though, is substantial when it comes to the origination of the courts. It creates the courts system, and it can go so far as to decide where court buildings are actually constructed in a particular state, these federal courts. Obviously, through the Senate's advice and consent role, the Congress has the ability to oversee who winds up being appointed to the judiciary. Each federal court has to go through the Senate. And so there is a role for Congress in the initiation of the court system, in the funding of the court system, and in the advice and consent role in terms of appointing judges that the president wants to see on the bench. But it doesn't have a day-to-day oversight role of the courts.
There are a number of ways that Congress and the court interact. Many of them are positive, some of them are less so. The Congress is responsible for all of the appropriations that fund the entire federal judiciary. So Congress appropriates all of the money for all of our federal agencies, and that includes our judicial branch, including the U.S. Supreme Court. Anytime money is involved, there's often conflict. So the courts have recently asked for salary increases for federal judges. The Congress has been unwilling to consider those. The courts have asked for increased security in the wake of several breaches of existing security at federal courthouses, and Congress has been more open to that, but hasn't fully funded those requests as well. So there's a lot of interaction between the courts and Congress on budgetary issues. There's a lot of tension between the two branches as well, because of course the Supreme Court has the authority to strike down acts of Congress. That comes out of Marbury versus Madison, 1803. And if the court believes that Congress has acted in a way that is unconstitutional, the court can invalidate a piece of legislation. As you might expect, that antagonizes Congress. Congress wants to be able to do what it wants to do. And as a result, the relationship between the two branches can get testy from time to time. The U.S. Supreme Court tries to be mindful of the fact that Congress is elected and the justices are not. But if the court determines that a particular action violates the Constitution, their foremost obligation is to strike that down and tell Congress that they have to start over.
Congress could have set up courts however it wanted to. It chose to set up a district court system such that federal courts could find themselves enforcing both federal law and state law. Federal judges are drawn from the states where they sit. In the early days of the Republic, Supreme Court justices were appointed regionally and would ride circuit to do appeals. And so just the creation of this court system, which is distributed, was an important way in which Congress created a really interesting court system that is simultaneously unifying, but also has kind of different regional inflections. It provides opportunities for members of Congress to be influential in appointing influential people to be judges, which is a pretty great appointment. So I wouldn't overlook kind of just the nitty-gritty of organizing the court system.
Increasingly, nominations to the Supreme Court have been incredibly contentious with the Senate. In part, it's because members of the court serve terms of good behavior, or we tend to think of them as lifetime terms. So for members of the Senate, they see this as sort of their one chance to determine the fate of the court moving forward. And of course, the Supreme Court has been called upon to decide all kinds of significant questions and all kinds of questions that have political implications for these members of the Senate. Issues related to abortion, health care, workers' rights, safety issues, criminal defense issues, gender equity. And those are all hot-button political issues for the Senate. And so they want to make sure that they are satisfied that a nominee is going to vote on cases the way they want them to vote. Nominees, for their part, will almost never agree to talk about a case or a topic that might come before the court. And so during those hearings, you can start to see some of the dynamics between Congress and the court play out through the focal point of that particular nomination. And often, the extent to which Congress and the court are getting along is really what's in the background of all of these hearings. When the court and Congress have a good relationship, and certainly when the court, the Congress, and the president all seem to be working in concert, nominees have a much easier time. On the other hand, if the court and Congress have been in conflict with one another recently, the nominees can expect it's going to be a very difficult confirmation process.
The main tensions between the court and Congress come when the court decides to exercise judicial review, which is done now over 170 times. And these are cases in which a court is basically saying that Congress has passed a law which is not constitutional. And so it's in those cases where Congress has the ability to do essentially two things. One is it can write a law to meet the terms of the court. It can say, okay, if you think this law is unconstitutional, we will write a law, and we'll write it in such a way that you might see fit to accept it within constitutional bounds. This doesn't happen as much as you think it might happen, actually, because it seems like it's difficult for Congress to address some of the objections to the court. And when it does, sometimes the court will maintain its original decision. The other is through constitutional amendment, and Congress has done this on numerous occasions, where it passes constitutional amendments essentially to try to address some of the shortcomings in the law. So in things going back as far as the 11th Amendment, you see Congress enacting an amendment or initiating the amendment process to try to deal with a court case. We see it further along with voting rights in several cases as well. And so including most recently a case that dealt with voting age. So you have situations where the Congress, because of its capacity to write a resolution, which can then become an amendment, so long as it can build a sufficient amount of support across the country, can actually try to check the court in that way. But I think it's really important to underscore that it's difficult for Congress to check the power of the court. I mean, if the court makes a decision and writes an opinion, there's really not a whole lot that Congress can do. And when it does try to do it, it finds it extremely difficult to correct the court.
I think to get into talking about the tension between the courts and Congress is to look at the judicial salary issue. Part of the reason that Congress has been unwilling to increase the salaries of federal judges is because the Supreme Court has been unwilling to consider putting cameras in the courtroom. And so here's an example of where the interests of one institution and the interests of the other institution are really in direct conflict with each other. The Supreme Court has really no interest in televising hearings in front of the court. Oral argument is very complicated. The advocates are often making very technical arguments, and the court doesn't want to see those distilled down to a 10-second or 15-second soundbite that might give viewers the sense that the court was going to do something that ultimately it turns out not to do. In addition, the court's really reluctant to put cameras in there because they don't know how it will change the dynamics of the relationships between the justices and the advocates. It's really hard to be an advocate in front of the court, and especially if you're somebody who's never had to do that before, it sometimes can be challenging, and the justices have to help draw out the arguments. And as much as anything else, they want to protect those lawyers from having their likenesses and their arguments broadcast to millions of viewers. Congress, on the other hand, will say, well, we've had C-SPAN since the 80s. People can tune in and watch us do all kinds of silly things. People, can engage with us in that way, and it's much better to be open. And it might sound like a strange thing, but the court and Congress are really at odds over this. In fact, about 10 years ago, Congress was telling the court, we are absolutely unwilling to consider a salary increase if you will not put cameras in the courtroom. And I think that really speaks to the tension between the branches. It also speaks to the fact that they have very different jobs and very different roles in our system. And sometimes it's really impossible to find a bridge between those two roles. Congress is supposed to be connected to the people. It is supposed to be accessible. The courts, on the other hand, their obligation is to the Constitution. They serve terms of good behavior. They aren't elected. They don't have to be reviewed highly in the eyes of the public. And I think the two institutions have trouble really reconciling those very different aspects of their institutional missions with what they each want from the other.